couple of ground rules before we begin. As everyone probably has noticed already, you are on mute. That is not an accident. Your microphones are not broken. And we're just doing this basically as a way to be polite to everyone, eliminating any background noise or distractions. I would also ask that you hold any questions until the end of the webinar. Rest assured, we will answer all questions that are asked. With respect to eliminating background, I can tell you from personal experience, now that we are working mostly from remote offices, like many other people are underneath the current situation, we have found that we have new office assistants in the way of dogs and cats that tend to bark and create noise and distractions. So we're going to be eliminating that here by putting everybody on mute. One other comment I can make too about questions, because I do want to hear your questions, and we can certainly answer as much as we can here this evening, or I'll reply later. Throughout the webinar, because I am asking everyone to hold their questions till the end, feel free to email a question if it does come to mind to that email address, info@wardpatent.com. I'll give you a second to write that down. It's info@wardpatent.com. So if you email your question, if it comes to mind and I'm quickly moving on to another topic during the webinar, send your question to that email, and then at the end of the webinar, we will go through all those emails in turn and answer any questions that may have been sent in during the webinar. For reasons we will discuss here in a few moments, please also do not disclose details about your invention that you're working on during this webinar. Again, we'll be talking a little bit of why that's important here in a few slides, but it's just good practice for me to tell you right up front. Please do not disclose details about your invention during the webinar when we finally do open up the mics and allow everyone to participate. And finally, as I mentioned, slides will be made available to all attendees following completion of the webinar. If you RSVP'd via Eventbrite, I have your email address, and I will make sure to send the slides to you. If you're joining us not through Eventbrite, but from another source, send again an email to info@wardpatent.com, and I will be sure to send you a copy of the slides. So with all those ground rules set, let's move on. Tonight's
participant is now
is
joining.
Called Keep Calm and Keep Inventing, Patent Basics During the Pandemic. What I will say initially is by way of a bit of intro. For those of you who don't know me, my name is Jake Ward. I am a registered patent attorney, owner of Ward Law Office. Our firm specializes in dealing with inventors, entrepreneurs, small businesses, and their intellectual property issues. And that includes patents, trademarks, copyrights, and trade secrets. In my spare time, I'm also a teacher. I'm actually an adjunct professor of patent law at the University of Toledo College of Law. And this slide deck that we're going to be going through, at least a good portion of it here during this webinar, is actually taken from day one, hour one of my patent law class at the university level. So we're all going to be getting a little bit of law school education here this evening. But fear not, I do try to make these presentations practical. That's my goal. The goal is not for anybody to come out of this webinar being experts in the subject matter at hand, but instead to maybe give you some good direction, some rules of thumb that perhaps you can take back to your respective businesses and projects and be able to apply it. So that's the goal here, folks, and I think we'll be able to accomplish that. Other than that, if you want to know any more information about me, lots of websites up there you can check out and do a little bit of stalking of Jake Ward on your spare time. Okay, so before we really dive into the meat of the subject, which is patent law, I wanted to address the elephant in the room, which is, why are we here? And it's part of the title for the webinar too, right? Obviously, these are troubling times. We're dealing with the pandemic, lots of economic uncertainty. But one thing I wanted to say, and I want this to be a positive sort of vibe throughout the webinar, is this statement here. And I've been telling this to all of our clients, all the companies that we work with for the past several weeks now. These troubling times too shall pass. And so why are we here? Well, it's because we know that things, life, the economy, business, it is going to move forward. All the pieces, parts are there. So even though we're in this temporary pause or slowdown, dealing with the current pandemic and the fallout of that, it's important for everyone who's an inventor, who's an entrepreneur, to be looking ahead. I'd say probably more important than ever. And I can tell you just by way of a little bit of recent evidence. We have seen personally at our firm in the past few weeks a surge in innovation, and really, it's really heartening to actually see this, because what are we dealing with? Well, it's a problem, and what are inventors and entrepreneurs really good at? Well, we're really good at solving problems, and so a lot of people, I think, have really picked up on this. A lot of businesses, but not only businesses, but independent inventors. And they're looking to contribute to help solve the problem. And when we're talking about solutions to problems, we're talking about intellectual property. And that's what we're here to learn about here this evening. So again, wanted to kick us off on a sort of a high note. Definitely troubling times, but I think we're all going to be able to pull through it. And hopefully this seminar gives us all a few tools to help in that process. Last slide, and this was actually a last minute addition to this webinar this evening. I was actually reading an article here earlier on medium.com. The link is actually at the bottom of this slide, but I thought it really interesting. The article here focused on multi-billion-dollar businesses, very large companies, right? But their origins was really the focus of this article. And I just thought it was fascinating. And again, I thought it really tied in nicely to this thought of, this too shall pass, business shall be moving forward. And all of our respective projects are also going to be moving forward even after the pandemic is over. The article was interesting. It looked at about a dozen or so companies that were born out of recessions, born in times of economic distress. I guarantee, unless you've been living under a rock, you probably recognize most, if not all, of those companies up there. Interesting article. And again, I thought it's sort of a nice, sort of a complimentary sort of statement to make relative to the webinar here we're giving this evening. So check that out when you get a chance. Okay, moving on then into the heart of the webinar this evening. What is intellectual property? So that's what we're here to learn about, right? The abbreviation you will hear me use over and over again is IP. This slide deck, like I said, I've evolved it over the past, 15, 16, 17 years now at this point. And at one point, I used to actually give and talk about what the legal definition of intellectual property or IP was. I put it up there. This is actually an excerpt from Black's Legal Dictionary, but I don't even bother to repeat it anymore. Like I said, for participants, inventors, entrepreneurs, I want to make this practical. And so when we talk about intellectual property, if you take nothing else home from this slide, I want you to remember there's 4 basic types that we're talking about. And those can be split into, for purposes of our presentation tonight, 2 groups. We're talking about patents and then not patents. And in the not patents category, we're talking about intellectual property like trademarks or copyrights or trade secrets. Now, each one of those, if the webinar tonight goes well, and I'm keeping my fingers crossed that it does, we're going to be speaking to each one of those other forms of intellectual property in future webinars. So tonight, and I've highlighted it, we're just going to be talking about patents. And of patents, there are some subtypes, which we will be discussing very briefly, specifically utility patents, design patents, and plant patents. But those are the 4 types of intellectual property to remember: patents, trademarks, copyrights, and trade secrets. Worth mentioning too, before moving on, most businesses have at least one of these. In fact, I think you'd be hard pressed to find a business that doesn't have at least one form of intellectual property as an asset. So it's very important to understand. This next slide, I think, is probably just as important. So we know what we're here to talk about, which is intellectual property. Why should we care? This number is actually been adjusted up and down over time. It actually came from an accounting report that I had seen at one point many years ago. I'm sure it's probably an inaccurate number, and I would guess probably a very low number. I'm sure it's even greater than as shown. But at some point in time, economists got together and tried to estimate what was the value of intellectual property, domestically here in the United States, if you were to sum it all up. And that's the number that they came up with. So why do we care about intellectual property? Well, it's like real property in a certain sense. It has an inherent value. $7 trillion worth of value. A lot of zeros right there. And again, I'm sure that is not even an accurate number. I'm sure it's even probably much higher than that. Coca-Cola is one of my examples that I sometimes use when I go out and talk in normal times, when I speak at chambers of commerce and technical associations about intellectual property. And in fact, if I had my video running right now, I would probably be showing you my handy dandy IP demonstration tool, which is this miniature bottle of Coca-Cola that I'm looking at. But as an example, Coca-Cola has been estimated to hold intellectual property worth more than $70 billion. I want you to think about this. If you were to take away everything physical from that company, you remove all of their assets, all their physical assets like buildings and equipment and inventory, right? Strip it down to the bare essentials, the intellectual property in the form of their trademarks, maybe in their designs, their patents. They do own patents. That company is still worth more than $70 billion. Where does that value reside? It's in the intellectual property, folks. And again, I tell that story to underscore, underline the importance of why we're talking about this here this evening. And it's because IP does have that value, and every business has it. Okay, so the intellectual property type we're speaking about tonight is patents. So rule of thumb number one, if we were going to take a test at the end of this webinar, and I'm not guaranteeing that we won't, what is a patent? What do I want you to remember? A patent is a negative right. What is it? A right to exclude others from making, using, selling, or importing an invention for a period of time. All right. What is that period of time? Well, we're going to learn here in a little bit. It's roughly about 20 years for a utility patent, but it's a negative right. It's a right to prevent others from making, using, selling, or importing your invention for that period of exclusivity. Why do we have a patent system? What's the policy? Well, patent attorneys like to think of ourselves as important because we get this constitutional nod, right? It's right in there in Article 1, Section 8, Clause 8. Congress shall have power to promote the progress of science and the useful arts. From that clause in the U.S. Constitution springs our patent system, our copyright system. All right, so there's definitely a constitutional nod there. The founding fathers did recognize the value and the importance of having a strong intellectual property system. I think if you take it, though, even one step further, at a 10,000 foot level view, what's the policy? Why do we have patents? Well, it's because patents encourage both investment and also early disclosure of new inventions to the public in a very orderly way. Some of you probably have seen patents. Maybe some of you have read patents, and you might be saying to yourself, Jake, I've read some patents, and it seems like gobbledygook to me. And there is something to that, but and it's primarily patent drafting strategy that typically dictates that. But still, it's a disclosure of the invention in a sort of predefined, preset way to the public. The nice thing about patents is even though you, as the inventor, have this limited right to prevent others from practicing your invention for that period of time, eventually patents and the inventions that they describe fall into what's called public domain, meaning anyone can practice the invention. Why is this important? Well, it encourages this early disclosure to the public instead of inventors keeping it secret, and ultimately the public gets to benefit from it. That's sort of the contract you have with the government in the form of the patent. They'll grant you this exclusive right for a period of time, but ultimately us in the public will benefit. and it promotes the progress of science and the useful arts thereby. So, policy level, in case you ever wanted to know. Now, if you go back to that previous slide, it gives you the right to prevent people from making, using, selling, or importing an invention. So this next slide here is important. What is an invention? And actually circling back around to very early in the slide deck when we were talking about the current situation, I want to tie this slide to that because we are all inventors in a certain respect. Why? Well, it's because inventions are just solutions to problems. That's really all they are. Okay. Simply having an idea like, oh, I wish someone could figure out a way to do X. That's not an invention. That's just an idea. But if you actually have figured out a way to do X, like, I could do X if I did 1, 2, 3 steps. You have solved that problem. You have invented. Now, even though we're all inventors and we probably all solve problems on an everyday basis, the trick is, from a legal standpoint, is that not all inventions are patentable. All right. So what does it take for a solution, for an invention to be deemed patentable? Well, there's 3 basic legal standards. All right. It's what we call the patentability requirements. The first one to remember is to be patentable, your invention must be new or novel. All right. Is it different in any way, shape, or form from everything that came prior to it? A little bit of legalese here. Everything that came prior, we refer to that as the prior art. Known body of knowledge that existed prior to your invention. Are you different? Does it work differently? Is it structurally, physically different? All right. Does it perform a different method? If it does one of those things, well, you may be legally new or novel and pass that first hurdle. The second requirement for patentability is that your invention must be useful. Okay. I teach patent law at the university level. We have 2 full nights on the law of utility or usefulness. I'll give it to you all here this evening. And was it 6 words? No. Is it landfill or isn't it? I say that a bit tongue in cheek. Obviously, it's a little bit more complicated than that. But I think that statement right there sums it up nicely. An invention technically does not even have to work well to be legally useful. If it works in some way, shape, or form, as advertised, it will meet that threshold generally. So most times when people chat with me about new ideas, inventions that they've come up with, right out of the gate, we can sort of tell whether or not this invention is going to be deemed useful or not. There are some gray areas, and I'd be happy to chat with people about that offline. But for purposes of the webinar, utility, usefulness, if it works in some way, shape, or form as advertised, it likely will be deemed legally useful. The third requirement of patentability is what we call non-obviousness. All right, a little bit more legalese here. You can see that word physida that I've put in there. Physida is a hypothetical person. It's a person having ordinary skill in the art, is what physida stands for. Person having ordinary skill in the art. And the question here for obviousness is, would that person have recognized the invention as being a predictable variation on what was already known? Okay. Would it have been predictable? Another way of asking this is the invention trivial? And that's why this obviousness standard really exists, is the government says, you know what, even if your invention is technically new, if what makes it new is of such a minor, trivial nature, you really don't deserve a patent, do you? And I sometimes will give an example when I talk about obviousness like this. What if, for sake of argument, you have a widget that you're selling, and in the history of man, these widgets have always been blue. And you decide one day you're going to turn that widget red. All right. It's new. No one's ever done it before. Maybe there's some percentage of people that like red better than blue. And so maybe it ups your sales. Possibly an argument for utility. People like it better. The question is, wouldn't a change in color be obvious? And the answer is probably yes. right? Such a change would be deemed trivial, you know. And comparing that situation then to maybe another situation where you've taken a machine and you've taken a brand new part never used in that machine before and put it in a different location in the machine, and now you get a 20% performance improvement boost. In a situation like that, is that an obvious change? There's at least probably some arguments to say, well, no, that wasn't obvious. I mean, especially if it gave a performance boost, and why wasn't somebody else already doing it that way? And you can imagine between those two situations where you actually build a new type of machine or versus just changing the color of an item, there's a lot of gray area. And this is where 9 times out of 10, when we ultimately try to persuade the patent office that you are deserving of a patent, the questions of patentability will ultimately come down to this obviousness issue. Anyways, to sum it up though, 3 requirements for patentability: your invention must be new, useful, and non-obvious to be patentable. Okay, so patent types. Now, a lot of people, I recognize a lot of the names here on the attendees list. So some of you have certainly seen different types of patents before. Some of you may not, though. This may be your first sort of schooling on patents. It's important to recognize that there's more than one type of patent available. Most people, when they think of patents, they are technically thinking of what is called a utility patent. And what do utility patents cover? Well, they cover processes, machines, articles of manufacture, like something that's been built, compositions of matter. Perhaps it could be a new type of formula, like a pharmaceutical. Especially in current times, maybe some sort of vaccine, perhaps, or a treatment for COVID. Improvements thereof. All right, business methods, which are generally defined as methods of using computers and the internet to conduct business type activities. Currently, the Supreme Court says they can in fact be patented. That law is in a state of flux. It has been for the past 6-7 years since a case called Alice Corp. But there is no per se rule against patenting of business methods. So if you have a unique type of computer implemented system, it may also be patentable. Utility patents are good for a duration of 20 years, give or take, measured from the filing date. The reason why I say give and take, there's a little bit of wiggle room in there. When you ultimately receive a patent, you will sometimes be eligible for what's called patent term adjustment, or PTA, depending on how fast the patent office was able to process and turn around examination of your application. But in general, it's 20 years. There will also be maintenance fees required, and we'll talk about that a little bit later, but you do have to pay periodic maintenance fees once you have your patent in order to keep it in force. Second type of patent that we sometimes discuss are what we call design patents. Design patents occupy sort of an interesting area between patent law and, let's say, copyright. What does a design patent cover? Well, it covers the look or ornamental appearance of useful articles. Duration of a design patent, it's 15 years from date of issue. So a little bit different than that 20 years from filing date. What's interesting about that 15 years from date of issue rule is there are no maintenance fees, no annuities required. You have your design patent, it's good for that 15-year span. Now, we're not going to be talking too much about design patents here this evening during the seminar, but I will say that sometimes products do lend themselves to it. Some of you may have heard in the news in recent years about 2 small companies called Apple and Samsung, and some patent litigation that they were both involved in. There were roughly 10 patents at issue in that litigation. 7 of them were utility patents, but 3 were design patents. And I think what's always interesting to note about those design patents is what was the argument effectively? Well, much of the argument was Apple telling Samsung, your phones look too much like ours. So I tell that story because I think design patents sometimes get the short shrift. Everyone wants to have the utility patent because it's generally seen as more valuable, but design patents, in that case, billions of dollars at stake, Design patents can, in fact, be valuable and sometimes should be considered depending on the nature of your product. Last type of patent to mention are what we call plant patents. There is a statute dedicated to plant patents. I'm here to tell you, if you have invented a new asexually reproduced, distinct, and new plant variety, you may be able to use plant patents to protect your new plant. Duration is 20 years from the filing date. I'm not going to say much more on that other than now you know plant patents do exist. So again, when thinking of patents, know that there's more than one type at your disposal. Okay, so at this stage of the webinar, when I teach this normally, this is where I say, let's talk a little bit about where you're at in the process. And one, when you are inventing, I think there's some good practices, things that you should think about early in the process before ever filing a patent application, in order to put you on a good footing and solid position if you do decide to ultimately seek a patent on your invention. And that's what these next couple slides talk about. So you've invented. What do you do next? Step number one, if you have an invention, and I encourage this, properly document your invention. And what do I mean by that? Well, you need to create a written description of your invention. It doesn't have to be in any particular format. It can be bullet points, it can be hand sketches, it does not have to be CAD, it doesn't have to be computer drawn, but it has to be a written description sufficient such that someone who's familiar with your field, that FASIDA, could pick up your document, read it, and say, I know how to do what they're saying, without requiring what we call undue experimentation or too much guesswork on their part. That's what I mean by properly document your invention. Why do we recommend this? Well, if we go back 9 years, and it's funny, I was joking with somebody the other day, I used to call the American Invents Act, our current patent law, the new patent law. But then I realized the other day, it's been 9 years since it was implemented. But if you go back 9 years prior to the current patent law in the United States, the American Invents Act, the U.S. used to be what was called a first to invent jurisdiction, meaning at the time, whoever was first to invent could claim that they actually deserved the patent. That law changed, like I said, 9 years ago with the America Invents Act. And we moved instead to what's called a first inventor to file jurisdiction. And under this current law, again, this is the law we're actively operating under, there is a bit of a pressure to get to the patent office sooner rather than later, because the first inventor to file will be the one who is deemed to deserve the patent. So it turned the patent system into a little bit more into a race to the patent office under this. Now, I'm mentioning it because we used to advise inventors, well, you want to reduce your invention to a writing and have it signed and dated and have a witness sign and date it because you were creating evidence of first to invent. You might be asking yourself, well, Jake, why does that matter if you're telling me it doesn't matter if I invented first anymore? And you're absolutely right. From a legal standpoint, first to invent, not nearly as critical as it once was. But I think there's still very good reasons, and it's good inventing practice to properly document your invention early. One of those reasons is I think it helps to crystallize in your mind. It's a practical reason. Helps to crystallize in your mind what really have you invented. Makes you critically think about it. All right. In the process of writing it down, you're probably going to think of different variations, tweaks, changes. Perhaps you realize, oh, well, that won't work. I have to do it this way. All right. So it's a good critical exercise to reduce your invention to a writing early in the process. Secondly, if you are going to travel this path, and we'll talk about the patent process here in a moment, you're going to need to be able to describe to the patent office, probably a patent attorney, what your invention is. And having this writing will put you well on that path. Finally, there are some legal reasons to properly document your invention, which I mentioned here in this slide. There is what's called derivation and also trade secret misappropriation, which we'll talk about trade secrets in another webinar. Derivation is just a tiny exception to this rule that whoever arrives at the patent office first wins. Derivation is a situation where someone steals your invention from you. And in that case, if they steal it from you, they derive it from you, and then they file first, they might normally be considered as the winner in the first to file situation. But if you notice up above, I said it's actually first inventor to file. So if they actually did not invent, they stole it from you. It doesn't matter if they got to the patent office first, they derived it from you, and you can prove that perhaps by your proper earlier documentation. So again, minor legal reason, rarely going to happen, but my advice is first thing to do, properly document your invention early. Second bit of advice before you get into the patent process, avoid a public disclosure. Going all the way back to the ground rules for the webinar tonight. Remember I told everyone, make sure when we turn on the mics, do not blab. Don't tell everybody what your invention is. Why was I so careful to make that statement early? Well, it's because you want to avoid what's called the public disclosure as an inventor. That includes telling a third party about the invention, offering to sell the invention, or actually selling the invention too early. If you do one of these three activities, you actually start a clock. It's a 1-year time period within which you must file the patent application, or you're going to be barred from obtaining a patent. Okay, it's sometimes called the on sale or public disclosure bar. All right. Now, in the United States, we're lenient because we give inventors this grace period, this 1-year period of time to sort of correct that. So if you accidentally sold your invention, at a trade show or to a company, and you started this clock, well, you can still file the patent application within 1 year in the United States, and that activity won't be cited against you. The problem is that many foreign countries have what are called absolute novelty requirements. That means that if you do one or more of these activities in some foreign countries under their foreign laws, that may actually bar you from obtaining patents. So if you had any thought of foreign patent protection, if a foreign market is important to you, I cannot stress enough, you need to avoid one of those activities before filing your patent application. Now, finally, I'll make a note here. Sometimes you can't help but disclose the invention. You need to be able to talk to people about it, and there is something to be said for that. You have to eventually trust someone in the patent process if you want to see your invention be successful and get out there in the market. How you handle that prior to filing a patent application is through the use of certain types of contracts or agreements called confidentiality or non-disclosure agreements, NDAs. All right. Most patent law firms that I'm aware of, they hand these out like candy. They're very important early in the process. And sometimes I'm asked the question, well, Jake, if I have someone sign an NDA, does that prevent them from stealing my idea? Well, the answer is no. Bad people will act badly. No piece of paper is going to prevent somebody from stealing your idea. But that's not the point. The reason why you have individuals sign NDAs, whether they're potential manufacturers, licensees, et cetera, early in the process, is you're trying to prevent this clock from starting. You want to avoid being barred from seeking a patent due to an earlier public disclosure or sale. And having an NDA in place, because it will be treated as a confidential disclosure, not a public disclosure, will prevent that clock from ticking. So that's the importance behind NDAs early in the process. Obviously, if someone does steal your invention and they signed an NDA, you do have a legal cause of action for breach of contract now. But again, the entire point behind NDAs is that gives you some freedom to basically work with others, disclose a little bit about the invention before having filed the patent application to help advance your business interests in the invention early on. All right. Third bit of advice I can give you about inventing and an action you should take before filing a patent application is conduct a prior art search. All right. So we said properly document as number 1, avoid the public disclosure as number 2. Number 3, conduct a prior art search. Sometimes these are referred to as patent searches, but a good search doesn't necessarily limit itself to just patents. Now, I will mention here, there is no legal requirement to conduct a prior art or patent search before filing a patent application. but we still highly suggest it. It is highly recommended for a couple of reasons. Doing a good search before filing, I think, is just a good business practice. You're doing due diligence effectively, and you may find that someone actually had your invention conceived before you. Maybe you find a patent from 1985 that described all the features of your invention. Well, now you know. Now you've saved the expense and the heartache of filing and fighting for a patent application that was doomed to fail. Okay? More likely than not, if you have invented and you really think your invention is novel, you might find in a good search earlier disclosures, publications, patents that are in the ballpark, but not necessarily the same. It's still a valuable exercise to do this search then, because that will allow you to write a much better patent application. As we're going to talk about here in a few moments on the details of patent applications, patent applications are intended not only to be technical documents, but also persuasive documents. You're trying to persuade the government that you deserve the patent. And how do you do that? Well, if you identify problems in the prior art and you can position your invention as being a solution, then you are going to have a more persuasive document. So knowing what's in the prior art allows you to write that much better patent application. Here on the screen, there are a couple online resources that you can use to do some informal patent searches. I will tell you, patents, by their very nature, are public documents. We're up over 10 million of them currently underneath the current numbering system. And almost all of them can be found on the internet. You don't have to use these databases. You can just use general internet searches if you'd like. But these are a couple good resources. There's the official U.S. Patent and Trademark Office database, which is found there, PATFT. It's very, very powerful. I like using it myself. The only comment I can make is sometimes to be really effective with it, you have to understand their code and their syntax a little bit, which you can learn. But for first-time searchers, maybe you don't want to go there first. Instead, I might suggest other resources like Google Patents. The Google company actually operates a patent database, patents.google.com. And most people are familiar with the Google interface, and you can use their standard Google interface to do keyword searches relating to your invention and see what comes up. And what you're really doing in these informal searches is you're asking yourself, is my invention new? Is it different in any way, shape, or form from anything I'm able to find? And if you can't find a single patent or publication that describes all those features of your invention, you're arguably new, and you've overcome that first hurdle towards patentability. At the bottom of the screen here, I do have some information on professional searches. There's some cost estimates in there. I give these cost estimates during these seminars not to scare people, but because I want you to be aware that there is a cost associated with securing intellectual property. I can tell you, to have a professional search done, it's most likely going to be on the lower end of that spectrum. Most products that I search, just within my practice, typically will be between $800 to $1,200 for a patentability search and legal opinion on patentability. You may run into the higher realm there if it's highly complex chemical, semiconductor type inventions, perhaps. The point of the story here is doing a patentability search. You have to sort of trust your gut. I mean, how comfortable are you knowing what you know? And if you feel very comfortable because you've been in your industry and you know what is and isn't out there, and you've done some informal searches, well, perhaps you can feel comfortable not having a professional search done. If you've done that and you still aren't comfortable with what you know, well, that's when you look at having a professional do a search. And the advantage is professional search agents can cover much more ground, much more quickly. There's search agents out there that I use. Some of them are former patent examiners, and so they know the ins and outs of the patent databases and how to search for different types of technologies in different locations. So it may be something where if you aren't comfortable, or maybe your investors aren't comfortable, because a lot of times patentability searches are very useful to seek investment, you can actually have a professional search done. So I think in any case, moral of the story here on the search page, at least do some informal searching yourself before filing a patent application. I think it would be time well spent. All right, guys. Appreciate everyone hanging on. We're going to be in the downhill slide here. A couple more slides. These are sort of text heavy, and I apologize for that. But like I said, I will be sending you copies of these slides after the seminar in case I skip over something or go through it too quickly. Trust me, you'll be able to read about it here later. So this slide here is where you have now done those three things that I've advised. You properly documented. You avoided the public disclosure, and you've done a search, and you feel after your search, yes, my invention truly is new. All right, so what do you do next? Well, we're going to be talking about utility patents, all right? And if you want to have a utility patent, which again covers machines, articles of manufacture, composition of matter, and processes, methods of making things, you will have to file a utility application in that case if you want a utility patent on that type of invention. What is a utility application? Well, it's a formal legal document, contains a full written description. That description is sufficient to teach that physida, that person having ordinary skill in the art, to teach them how to practice your invention. There will be claims. The claims are the legal definition of the invention. The one saying at the patent office is the name of the game is in the claim, because it is critical. It is where the invention, how the invention is defined. Thinking of it in terms of a physical property, it's the metes and bounds of this property you're claiming to be your invention. So a formal utility application will have a full claim set. There will also be drawings that meet all the drawing and legal requirements set forth by the patent office. In fact, we hire patent artists. If anyone out there is artistic, know that it is a job to actually create patent artwork, and very valuable job. And your utility patent application most likely will have to have drawings that meet those patent office standards. What happens with that utility application is it is assigned to someone called a patent examiner. And a patent examiner is effectively like a judge and jury over your invention. This is the individual at the patent office who is tasked with determining whether or not your invention meets those legal standards. Are you new? Are you useful? Are you not obvious? And also that you comply with all the other rules. We'll talk about examination in the next slide. Immediately upon filing, and this is important here, you are what's called patent pending. I'm asked this question, at least 3 or 4 times a week. You are patent pending as soon as we file your patent application. We don't have to wait for anything back from the patent office in order for you to be able to start calling your invention and marking it as such. What does patent pending mean? Well, it means you have lodged your invention with the patent office. Doesn't mean you actually have a patent yet, but you are at the patent office, you're in the process, you are pending at the office, all right? And that's what that term means when you see it on products and late night TV. It doesn't have a whole lot of legal teeth, I will say. You can't sue somebody when you're just patent pending, but you have all the right in the world to bark at people. It places the world on notice that you have taken steps with the patent office to secure your rights, and if they copy, they're doing so at their own risk. Last line here on this slide, and like I said, I put costs in these presentations because people ask and you need to know, but every case is different and yours may be less or more. But for a sort of moderate complexity mechanical type invention, you might expect costs of up to about $6,000, including formal drawing fees, including the government fees, and also then the professional attorney fees to prepare and file a patent application. So if you're interested in numbers for budgeting purposes, that's a good number to sort of keep in mind for the patent process. Like I said, once you file your patent application and you are assigned to a patent examiner, the examination process begins. There's something also called prosecution, which you may hear your attorney talk about or your examiner talk about. Prosecution is the arguments back and forth with the patent office during the examination to ultimately result in the patent being granted to you. One way of thinking about it, it's like a negotiation. So the applicant, the inventor, or their attorney negotiates with the examiner. The examiner cites prior art that the examiner finds. The applicant then explains how they're different, how they're better, Maybe sometimes they can amend or revise the claims of their application to really distinguish and pull out what makes them different. Um, this process can take on average about 2 to 3 years. It's a fairly lengthy process. Something else a lot of first-time inventors don't realize, and they're sometimes shocked to hear this, but very often, I would wager probably 8 to 9 times out of 10, you will be rejected by the patent office initially in your application. It's sort of shocking to hear that the first time, but when you think about it, it does make a perverse form of sense. Patents are valuable. They're like property. We're going all the way back to the trillions of dollars slide, right, that we were talking about earlier. And if all you had to do was pay a fee and get a rubber stamp, well, then anybody could get a patent, and it would drive the value of them way down. All right. So they make you prove. You have to jump through the hoops, and you have to prove to the government that you are, in fact, deserving of the patent. That's why this process takes so long. It takes 2 to 3 years. If you file a patent application today, you probably don't expect to receive an examination, a first action in examination, for about a year. All right. The reason, too, to mention here is there's roughly 10,000 patent examiners currently at the patent office. 10,000. That's double what it was when I started practicing, 15, 16 years ago. So they've done a great job at adding to the examiner corps. The problem is that even though they've doubled the number of patent examiners, the number of patent applications being filed every day continues to increase. Last number I saw, it's somewhere between 750 and 850,000 patent applications currently on file at the patent office. And so if you're running the numbers, 10,000 examiners seems like a lot, but not when they're facing 800,000 patent applications and more are being filed tomorrow. And it takes time to read through these applications. That's why it takes so long to actually go through the examination process. And also, unless you're paying for what's called expedited examination, generally it's a first in, first out system. So your application comes in, it goes on the bottom of the stack, and your patent examiner has to read down through everything that came before you before they get to yours and do your examination. So a little bit of explanation about why it takes so long. Rest assured, you are still patent pending during that entire period, though, and continue to market yourself as such on all your websites and labeling, et cetera, throughout that entire time. Next line here, because people will ask, how much does this cost, Jake? And I will tell folks that the good lawyer answer is it depends, which I know isn't helpful, but it really truly does. And no one has a crystal ball. You don't know what you're going to get into at the patent office until you're actually there. You might have some sense from searching that you did beforehand. But I tell folks, for budgeting purposes, because that's what's important. How do you budget for this, even with the unknown qualities of patent examination? I typically say it's going to be about double. It would be about the same as what you use to prepare and file the patent application. So if I said about 6,000 to prepare and file, you might expect another 6,000 over 2 to 3 years to go back and forth with the patent office. That number includes attorney time, that includes government fees, et cetera. And it basically, again, is based on a couple rounds of back and forth with your patent office examiner over that span of time. Ultimately, the goal here is that you receive what is called a notice of allowance. This means that you have, in fact, reached an agreement with the patent office, and your patent will be granted to you. Now, the government still at this point does take its ounce of flesh, and you must, in fact, pay what is called an issue fee. And the patent will be granted after payment of that issue fee, typically about 6 to 8 weeks after that's been paid. But it's mechanical at that point. Once you reach that agreement, your examiner has in fact agreed that your invention is patentable. Simply by paying that issue fee, the patent will be granted to you at that point. Finally, and I mentioned this earlier, patents are good for that 20-year period from date of file on average. But there are those regular maintenance fees, effectively every 4 years, and it opens up in windows. So at the 3.5-year mark, your first window opens, 7.5 second window, third, 11.5 third window. You can see here too, for both issue fees and the maintenance fees, I've put different numbers on there separated by slashes. Some of you may be wondering why Jake did it that way. Well, it's because the U.S. Patent Office has 3 different fee schedules. And this is actually a good thing for independent inventors and small businesses. If you are a large company, more than 500 employees, you have to pay full price. It's what we call large entity. That would be, for instance, the issue fee of $960. If you are a small business, fewer than 500 employees, you get a 50% reduction in that fee. You're what's called small entity. More recently, again with the American Invents Act, we now have what's called micro entity, and there's a complex series of questions that would need to be answered to determine whether or not you are a micro entity. But many times, independent inventors who have not filed very many patent applications previously do qualify for this. And if you do qualify, and by the way, it's tied a little bit to a gross income question, which is always awkward to ask clients, but it is the law. If you qualify, you get a 75% reduction in fees. So what I would say is, if you're an independent inventor and you want to know if you qualify for micro entity, speak with your attorney, and they'll ask you the series of questions so they can then certify that you do qualify and can use the 75% reduction in fees at the patent office. Okay, everything I just talked about, you must do if you want to have a utility patent. You have to go through examination. You have to have a sufficient filing, a full written description, claims, drawings, etc. And it is expensive. But for that reason, the government has what is called a provisional application option. Now, first thing I want to mention, and because sometimes we as practitioners, we hear this and we just sort of grate when we do, there is no such thing as a provisional patent. Provisional patents do not exist, but there are provisional applications for patents, and provisional means temporary. And the whole idea behind a provisional application is it is just a stepping stone to that regular utility application that we were just talking about a moment ago. And the idea behind the provisional process, why it's great for small businesses and independent inventors, is it allows you 1 year to test the waters with the patent pending status, to go out there, seek investment, make your prototypes, perhaps test the market, make sales. And over that year, the idea is through informally lodging your invention with the patent office, you can call yourself patent pending, do these activities, and then be able to make the informed decision: is it going to be worth my time and my money to press forward into examination or not? So it's a great tool, provisional applications. I highly recommend them for inventors who have a concept and they're thinking about pitching it, whether for licensing or for investment for venturing. What is a provisional? Again, it's an informal document. It's written description which can include informal drawings, even though black and white line drawings may be required for the non-provisional regular patent application. For provisionals, we can get by with hand sketches. We can get by with photographs of prototypes. The point is that description still should be able to describe the invention with enough specificity such that someone could pick it up and read it and understand it. But you don't have all the formal legal trappings of the regular non-provisional application. And because of that, it can be prepared much faster and also less expensively. There's a price range there. Typically we would quote between $600 and $2,000, depending on the level of involvement you want from your attorney in the process. That number is inclusive of the government fees. Government fees will be anywhere from $140 for small entity to $70 for micro, underneath current fee schedules. Another nice facet of the provisional process is that application is never examined. Think of it this way: your filing of the provisional application simply plants the flag at the patent office, gives you that all important filing date, and allows you to call yourself patent pending for that 1 year period to go out there and test the market. Nothing happens. No examiner's going to pick it up. Another nice facet here is maybe at the end of the year, no one hopes this happens, but it does. But at the end of the year, maybe you find out this wasn't as great an idea as I thought. Maybe there's no interest in it. It just didn't move. In that case, you can let that provisional go abandoned. And the nice facet of the provisional process here is it is never published. So unless you had actually disclosed the invention to someone, no one would be able to know the contents of that provisional application you had filed. What people hope happens, though, is at the end of the year, there is a light at the end of the tunnel. You have sales, there's interest, etc. And what you do at that point in time is you file that regular non-provisional application to kick off the examination process, which we described earlier. And the way the system works is if you file that non-provisional application before the end of that 1-year period with the provisional, those two documents get linked together like a chain, all right? And that's important because when your patent examiner goes to start examination on your non-provisional application and asks, are you new? They can only look at what was publicly available prior to the earliest filing date. And if you filed a provisional first and it's chained to the non-provisional, that means that anything that happens over the course of that 1-year period of provisional status cannot be cited against you by the Patent Office. So the Patent Office will only be able to cite what was publicly available prior to the provisional filing date 1 year ago. Again, so it's another nice facet to the provisional process. Like I said, advantages we've just walked through there. You can use the patent pending status just as if you filed a non-provisional application. We also mentioned here that you can file more than one provisional. So maybe you have your initial invention, you file a provisional on it. 3 months later, you realize, oh, there's this key improvement. Well, you can file another provisional on that key improvement. At the end of the year, you sweep up both provisionals into the non-provisional application. So more than one provisional can, in fact, be filed. Just remember, no such thing as a provisional patent, though, but remember, it is a tool and it's a stepping stone to that regular utility patent application that starts the examination. All right, we're almost done, guys. You've been great. I know it's been almost 1 hour here at this point, so I apologize. I'm a lawyer and I like to hear myself talk, but we're almost to the end of it. So you guys have been great. Everything I've talked about up until this point relates to U.S. patents. This slide is important here because patents are territorial. That means that they're only good in the countries in which you wish to protect your invention. So if your market is the United States, you want a U.S. patent. If your market's Canada, well, maybe you want a Canadian patent. There is no such thing as a worldwide patent. Now, funny enough, there is, by virtue of a treaty called the Patent Cooperation Treaty, or PCT, such a thing known as an international application. Now, an international application does not result in an international patent, but think of it like this. It's somewhat like a provisional application because it tolls the time. If you file an international application, you get up to 30 months, and in some cases 31 or 32, depending on the country, but 30 months on average, 2.5 years, to decide which foreign countries you want to seek patent protection in. And so it's a great process, great procedure that's available to sort of allow you to become patent pending internationally and yet not have to incur substantial expenses at the outset filing in, let's say, a dozen foreign countries at once. Again, tolls that time for 2.5 years, 30 months to allow you to test the market and then really have an informed decision that you can make at that point as to which countries, if any, will be worth seeking patents in. It is more expensive there. You can see for a small entity, we estimate about $3,000 total, including government fees, for an international application filing. In that case, again, think of it this way: it's 153 plus countries currently party to the PC Treaty that you're becoming patent pending.
Unknown participant is now exiting.
Of those fees. All right, final IP thoughts, guys. Like I said, you've been great here. Remember, IP has always been a long-term tool for businesses. We're talking about timing of 20 years for patents. The current crisis does not change this fact at all. And like I said, I can testify, from personal experience, surge of innovation right now, people solving problems, inventors solving these problems, and IP is a key facet to that. I want you to also remember that know that securing intellectual property is a process. Hopefully, you from the presentation tonight, you've understood that. You simply don't file a patent application and walk away. You do, in fact, have to fight for your patent right the majority of the time. And again, it is a process, but not one that is insurmountable. Hopefully, you come away with this with the understanding that IP it can be a powerful business tool. It can help you to protect your inventions, can ward off competition. We didn't really talk about it too much, but we did mention you can use patents to secure investment and funding, but you can also monetize or make money off of your invention in more than one way. You can do it through licensing or assignment. You don't actually have to make your product and venture and sell it yourself. Licensing is in fact a very viable option, and sometimes the preferred option. So again, to end, hopefully you can now take advantage of your IP, recognize your inventions, your solutions to your problems you have in your respective projects and businesses, and know that you can actually take steps in that case to protect and to monetize and take advantage of your intellectual property. Last thing I'm going to mention here, again, this is sort of a late addition to this webinar too. I just thought this was great. And I think, again, looking at the crisis that we're in, people pulling together, the intellectual property community pulling together. This has been sort of publicized a little bit over the past several days. There's now this open COVID pledge. Many companies, large companies, have now pledged that they are going to lend their intellectual property in a license. They're pledging to give a free license to their intellectual property if it can be used to help solve the crisis, to create tools or treatments or equipment that help people who have been affected by the virus. And you can go to that website, opencovidpledge.org, to see the companies that have signed up. But it gave me just a really good feeling to see our IP community really banding together and in this time of crisis and trying to help people. Like I said, IP doesn't go away because of the situation. If anything else, I think it helps everyone to maybe pull through it in a stronger position at the end of the day. That being said, I'm going to now open it up. I'm going to see, I've been avoiding my phone during the entire seminar, so I'm going to see who has emailed me questions, and we can take those questions. Also, even though I muted everybody at the outset, you all have the ability to unmute. So if you right click on the little microphone next to your name and you say unmute, you should be able to unmute your mic and ask a question. So while everyone is figuring that out, I do have one question here. This is from Jeff. It says, do you have any insight into how the application process has changed right now? Are things taking longer than the typical process, whether it's for a patent, trademark, etc.? And Jeff, I think that's a great question. We, in fact, are seeing some policy changes at the patent office right now relating to the current pandemic. Currently, and I actually have been asked this question a couple times today, legal deadlines for filing patent applications. So for instance, that 1-year deadline for filing a regular application after filing a provisional, currently those deadlines are staying where they're at. Those have not been adjusted. What the patent office has offered at this point, however, is for certain prosecution deadlines that fall within this basically 6-week window or so, here in from end of March to end of April. If you have a deadline for responding to an office action from the patent office, that can be extended up to 30 days now. And all you have to do is basically make a statement, a declaration on the record that you've been affected by this pandemic, and therefore you need the 30-day extension in order to be able to make a proper response. So it involves a lot of prosecution sort of deadlines associated with appeals, as well as deadlines associated with the Patent Trial and Appeal Board, which is the sort of litigation light, which we really didn't touch upon during this presentation. Same thing applies. That 30-day extension also applies with prosecution deadlines in trademarks. In terms of workflow, I haven't really seen too much of a difference. I'm still speaking with examiners, both at the patent and also at the trademark office. One thing I can tell you is the patent office in recent years has become much more of a remote working environment already. And so many patent examiners already were set up to work from home offices. And so in terms of the general ebb and flow of work coming from the patent and trademark office, I haven't seen too much of a difference. I'm still speaking with patent examiners every day. We wish each other well, hope everyone's staying safe and healthy, but it's not been too disrupted, I don't think, at this point. So I'm looking through here. So it's a great question, Jeff. Anyone else, if they want to, unmute and feel free to ask a question. And I'm looking in my email inbox here to see if anyone else asked a question. If no one asks any questions in the next 2 minutes, I will immediately erupt into my Disney rendition of a Disney song. Oh, there we go. I knew that would. I was going to say something like Lion King, perhaps, but I have a webinar question now from Todd. No one wants to hear me sing. Thank you. If you want to use current products and configure them in a way to use in your invention in a way they were not intended, but only need modifications, would you want to file for a utility patent? Do you sometimes need a few different patents to protect your idea? So actually two questions there. And if I understand the first question correctly, if you want to use current products but configure them in a way they were not intended, can you file for a utility patent application? The answer is yes. And in fact, I would venture to guess the majority of inventions are made with that strategy. And think of it this way. If you go to the hardware store and you walk up to the shelf and you pull off 10 parts off that hardware store shelf, each one of those 10 parts is obviously known. It's being manufactured by somebody else. It's a known product. But if you take those 10 parts home and you now assemble them in a new, useful, and non-obvious way, right? You have now invented something, and that invention can be the subject of a patent application, a utility patent application. So it's not dictated by whether or not the pieces, parts, or the components are new or being used in their conventional way, but whether or not you have either built something that's brand new or are using those conventional components in a new way that was not previously known or considered. That could form the basis for the patent application. Your second question is interesting too. Do you sometimes need a few different patents to protect your idea? Yes. Yeah. And if we were in normal times and I was standing in front of our room and speaking to you, I would be holding up my phone right now, and I would be showing this to you. This wonderful piece of machinery that we all have in our pockets now. Supercomputers in our pockets. It's not a single invention, right? I would venture to guess there are hundreds, literally hundreds, of patents covering hundreds of inventions, all wrapped up in this product. So a product and an invention are not necessarily synonymous. You could have 2, 3 inventions built into a single product, and that's what makes it valuable. Think of patents too, to answer this question, going back to my property analogy, patents are like fences. You're really fencing off that property, which allows you to either sell it or, in the case of licensing, to lease the property. And you can sometimes fence off your property from different angles. Maybe it's larger over on that end than it is down here. There's different ways of actually protecting your products and your inventions, and sometimes different patent applications are called for. Something else to mention there too, going back to the patent types. Remember, I mentioned design patents. It's not uncommon, depending on the type of product or invention you're working for, that you might file not only a provisional or utility patent application, but also a design application. maybe your invention does have some novel, useful features, some utilitarian features that you want to cover, but it's also a very simple product, doesn't have a whole lot of moving parts. Maybe the look of it is interesting or unique just by the very nature of it. You could try to protect the utilitarian useful features, the functionality, through a utility patent, and then also file a design application on the product configuration or look as a whole. So these are not exclusive forms of intellectual property. They can sometimes be used in tandem, in conjunction, to try to fence off your property, in the broadest way possible. So great question. Great question. Scrolling down through here, see if I have any more questions. Brad, all right. Brad says, great webinar. How ready does an invention need to be when I go to my patent attorney? Does the documentation have to be complete? For example, I know exactly what the drawings might look like. Does it have to be reduced to practice? How much of an interactive process is required with my attorney? All right, so great questions. How ready does it have to be? I will sometimes turn people away, Brad, when they come to me too early in the process. And how I know it's too early is when they come to me and they say, I wish someone could do X, or I wish there was a way of doing Y. They've conceived of the problem, but they have not yet solved it. In that case, where you just have an idea, I think you're probably too early to talk to your patent attorney. What I oftentimes will do to people at that early stage, where you still can't verbalize how to solve that particular problem or how to make or use this thing, is I recommend that they speak with individuals such as design engineers. And I have a fairly robust list of referrals. Again, I'm the hired gun on the legal side. I fight the good fight for you at the Patent and Trademark Office. But by virtue of my business and working with lots of different inventors, I do have good contacts, and so I'd be happy to refer anyone who has an early stage idea, sort of the seedling of an invention, to one of these design engineers to perhaps actually create an invention. Figure out how the machine is going to actually be put together and work. Now, taking it one step further, do you have to have, how complete does the documentation have to be? You don't have to have a working prototype, all right? You don't actually have to reduce your invention to practice. That is not required. So, in fact, I would say the majority of patent applications are filed without there actually being a prototype, a physical prototype at the time. If you have a physical prototype, that's great. No worries there. I mean, and in fact, I encourage you to make prototypes, because it really does help to sort of ferret out any problems that there might actually be with the invention. But in order to file the patent application, it's not legally necessary to have the prototype. What you need to be able to do is you need to be able to, in writing, describe with enough specificity how to make and use this invention if you had the means, if you had the funds. When you go to the patent attorney, like I said, I encourage you to have something in writing, but you don't have to have a novel written. It can be hand sketches. A lot of times, the value of actually speaking with the attorney is giving them an opportunity to ask you the right questions, so that they can then pull out of that discussion what would be necessary to actually go to the patent office. So I would say, if you feel you've successfully conceived of the invention, you know what your solution to the problem is, you have a general idea how you might do it, and you could in fact maybe sketch it out or bullet point describe it. I think at that point you would be ready to speak with an attorney. And like I said, we're all fairly friendly. We like talking to people because it draws us away from the boredom of staring at patents all day long. So we would certainly tell you if we think you're a little too early, and maybe give you a nudge in the right direction to try to commercialize or get your invention to the point that it's closer to commercialization and closer to patenting. So great questions though, and it is interactive. Again, you don't just go to the patent attorney, drop the file on their desk and walk away. Yeah, I will mention here, and I joke about this, but it's sort of true. Picking a patent attorney is a little bit like dating, right? it's a long-term process. We've talked about that. It's going to be years. You're probably going to have to be involved with this patent attorney. Even after the patent is granted in the next 3 years, there's going to be maintenance fees, and I'm going to be knocking on your door in 4 years after that, and 8 years after that. So it's a long-term relationship. By and large, most of us are fairly competent. You actually have to pass a couple different bars to become a patent attorney, not only a state bar, but also a patent bar, they call it, at the U.S. Patent and Trademark Office. So because of that, we're, like I said, by and large, most of us are fairly competent. And so I'd say work with a patent attorney that you feel comfortable with. Interview a couple. If ultimately you click with somebody, go with them. Because you're probably going to wish that you were working with them if instead of picking someone else and get a couple years down the road in the process and realize I really don't like that guy. So, but it's a good question. It's an interactive process, and definitely, I said, interview your patent attorneys and make sure you feel comfortable who it is you're going to be working with. So I will take one more question if there is any. Feel free to unmute or send me an email. I'll do a countdown here. Give it another 15 seconds. Great questions, I can say, by the way. One thing I would ask, for some honest feedback. Like I said, this is our first webinar that we've done. We're using the Microsoft Teams platform for this. Obviously, there are other platforms out there like Zoom and GoToMeeting, but we did decide to try this first webinar on Teams. If there were any serious glitches that you found as you participated, everyone has my email here on the screen, info@wardpatent.com. Would certainly love to hear your feedback, negative or positive. You won't offend me. And again, we are hoping to have more of these webinars here in coming weeks, perhaps talking about trademarks next. I also generally do teach on my speaking circuit a interesting webinar or seminar called "You Don't Need a Patent If," which is a lot of the same information, but from a fresh and interesting angle. And so we may do a webinar like that as well if there is sufficient interest. All right. So with that being said, I think we're at the point here where we're going to shut down for the evening. I do appreciate everyone attending. Like I said, my name is Jake Ward. You have my contact information. If you did not join by RSVP, if you joined in some other way, send me an email just so I can make sure to send you the slides for this seminar. Otherwise, like I said at the beginning, I'll be sending everyone who RSVP through Eventbrite the slides here, if not this evening, by tomorrow. So again, very much appreciate your attendance. Hope you all have a great evening. Stay safe, take care, and hope to see you at the next webinar.